Good afternoon, everyone. Thank you so much for being here. It is a privilege to be with you today on this beautiful fall day in Colorado. For those of you who are here, it is spectacular out. I am delighted that you're interested in estate planning, especially the specific topic of why you need an estate plan now. My name is Kate Soburn. It says Catherine, but I go by Kate. I am an elder law attorney in Lakewood, Colorado, and I practice in the area of estate planning. I also do guardianships, conservatorships, probate administration, and litigation. I am also happen to be a hospice chaplain. I have been in that role for years. I did stop being a chaplain once my son was born, but I fully intend to return to at least being on call. I'm from Colorado. I grew up in Crested Butte, Colorado. And although I have lived in New York and studied on the East Coast, I spent decades on the East Coast and also lived in Europe. Called Colorado home, and I'm delighted to have been back now for over 20 years. In terms of my all-important why, I am obviously very passionate about good end-of-life care, not only from the perspective of an attorney. Of course, you should have the correct legal documents that allow for the smooth transfer of your wealth when you pass. Absolutely, that is very important. But I am also extremely passionate about the documents that are in place before you pass when you can no longer make your own decisions. And those include advanced care directives, your powers of attorney, and a slew of documents that I do that I don't think a lot of people do, but I believe having more direction in place as you decline. And even if you're not declining, in case something catastrophic happens, more directions are better. So basically, are you ready for 2024? Of course, no one knows what 2024 will bring, but I'm often accused of planning for the worst, but I always hope for the best. But I would be remiss if I didn't give the cautionary note that you are at risk without an estate plan. Your family is at risk. With the unknown comes the idea that we can push our estate plan off and off and off, and we don't need one. We're not sick. We don't need an estate plan. But unfortunately, things happen. Catastrophic things happen. Illness happens. Dementia happens. And we're not able to adequately prepare for these things, especially for the people we love. So the unexpected happens. We have done nothing to prepare. If you don't have powers of attorney and you become incapacitated, or you need someone to help you with your finances, or you need someone to help you with your healthcare decision making, you have to go to court and get a guardianship or conservatorship. You are not in a good position then. That is far more expensive than doing an estate plan. And I recommend planning for incapacity long before it happens. And then, of course, if you pass suddenly and you don't have a will, you are left with what's called an intestate proceeding, a proceeding with the court without a will, where your assets have to be transferred to your heirs. And these may be people that you do not want your assets to go to, but by law, they get them because they are your heirs. So you really want to leave directions, and you want to leave a solid will that administers your property the way that you want it administered, and to do other kinds of planning, designating beneficiaries on accounts, maybe doing certain kinds of deeds wherein your real property, your real estate will not pass through probate. We want to have a good, solid plan that's efficient, that's relatively inexpensive, and that is tailored to exactly how you want things to go. So, do you have plans in place? Most people have an idea of where they want their wealth to go, And if they weren't able to make decisions for themselves, if they were ill, who they would want to make those decisions. But unless we memorialize those things in writing, it doesn't necessarily happen that way. Most older people I know who have grandchildren would like to provide for those grandchildren something. Usually it's for education, but it can be for other things as well. In Colorado, if you're married or unmarried, if you have a partner, if you have a spouse, if you're just living with someone, these are really important things to think through legally. And marriage is fairly obvious, but what may not be obvious is the fact that in Colorado we are a common law marriage state. And with a common law marriage state, you can be deemed married whether you intend to be or not. And your common law spouse will have a claim to a portion of your estate. And depending on the length of the common law marriage, the vast majority of your assets. So you will be really careful in Colorado if you're going to choose to live with somebody. And if it's a second marriage, all of those things need to be considered when thinking about doing a plan. And of course, that includes children from a prior marriage for both you and your partner. And then, of course, another important point to consider is long-term care needs. Sometimes we do planning in anticipation of Medicaid. Unfortunately, in our healthcare system in this country, it does not provide for long-term nursing home care. So it's very expensive. I'm sure I'm not telling any of you anything you don't know, but it's something that I contend with because I would be remiss as your attorney not to have a talk about anticipating this need if there's long-term care insurance in place. If not, what to do then, and to really at least have the conversation about how that might be paid for and planning accordingly. I put your pets here because we here at Rocky Mountain Elder Law are big fans of animals and including them in your estate plan. One would be surprised. Often this is overlooked. I think it's really important to designate someone and talk to someone about taking your pets in case something happens to you and making a financial provision for their medical care and care. Surprisingly to some, parrots are really important. They can live over 100 years. It's really important to create some kind of trust vehicle to manage the care of that animal. I've done pet trusts for llamas. So I've done them for all kinds of animals, but it can give one a sense of peace about how things will go should something happen. And obviously your financial assets. One of the things that I like to do is take a complete inventory of how your property, bank accounts, everything from your basic checking all the way to investment accounts, how they're titled, who the beneficiaries are, if that's who you want the beneficiaries to be. Is there a backup beneficiary? Do we want your estate to be the beneficiary? Would that be advantageous to you? Do we want a trust to be a beneficiary? We want to have a discussion about all of those issues to make sure that you have a clear understanding of where your assets will go, whether they will pass inside or outside of probate. And we want to have all those boxes checked to make sure that whomever is designated is who you want those funds to go to. And of course, all of this is about your legacy. I often talk with clients about what their why is, where they want that, not just their financial bounty to go to, but who they want to have the conversation with about making decisions for them in case they can in the future. The choice of your agents under your powers of attorney for both financial and medical, the choice of your executor or personal representative under your will, the choice of your trustee, this is all part of your legacy. It is not just your money that's your legacy. It's also who will make decisions regarding your care and your finances for you. To me, that is all part of your legacy. So the point I'm trying to make is that estate planning is not just about documents. It's about peace of mind. It's about being clear in your head and your heart and your spirit that things will be handled in case you can't handle them. And that's everything from your care of your person, your health care, what kinds of decisions will be made in certain situations, to obviously the financial decisions. If something should happen that you can't write the checks or can't pay the bills, that there is someone in place whom you trust to handle all of that so that your home, your assets are looked after. And it is so important to have those decision makers in place. Just to give you an idea about, I feel this is so important that whenever a friend of mine or myself has a child who turns 18, they have to do a medical power of attorney right away. It is because of the privacy laws and the HIPAA laws, the people who are close to you cannot get access or help make decisions without these documents in place. So we want to, as soon as child turns 18, have their own medical power of attorney where they name either their parents or someone they want to help them look after their health care at minimum. And if the 18-year-old can't afford legal fees, I do those for free. That's how strongly I feel about the importance of planning. So again, just to emphasize, preserving your legacy is far more than your assets. And how we get at your values and wishes are we talk about different scenarios. In terms of the advance directive, there's a statutory form that I use, but I have added to it. It not only includes a terminal condition and what's called a persistent vegetative state, which is a whole other situation, but I also include COVID-19 and its variants. I also do planning for dementia. My dementia form has mild, moderate, severe dementia, and what kind of care you would want in each of those situations. So when I do an estate plan, I really try to drill down to, okay, the situation is X, and these are your choices for care. What would you like? And leaving these kinds of directions is truly a gift to the people who care about you and love you, because it leaves them of those kinds of decisions, and you are basically giving your blessing to make some of the most difficult decisions they will ever have to make. Obviously, an estate plan can safeguard your family and your family's financial well-being. It's so important to do that inventory and figure out where, if you have no plan, where all your assets will go and to whom, and whether there are tax consequences to those transfers. And then if you do have a will and or a trust, where those assets will go, and if there are tax consequences, and how you can direct your money to not just obviously family members. If you die without a will, it goes to your heirs at law or family members. With a will and you leaving directions, you can leave it not just to your family members, but also to other people. If you would like to make a gift to a friend or a university or a radio station or wherever you would like. So you have so much more control over your assets and your life, including the end of your life, with an estate plan in place. We've talked a little bit about pets, so it may be of interest to know, what does a pet trust look like? Well, it's usually embedded in a will that I do. It designates a trustee who's also the guardian of the animal, and it provides a certain sum for their care, including any medical costs. And it's just a very wonderful gesture to do. In advance of all of these documents, I'm a very strong advocate having the conversations with not only who you choose as your agent under your medical power of attorney, your agent under your financial power of attorney, your personal representative, but also choosing who will take the dog. And then talking to that person and saying, I'm doing some estate planning and I want to leave a certain sum, and name you as trustee and caregiver of the pet. And if that person says, I don't want the dog, you really need to know that before you memorialize that in a will. So the conversations are really important. It's particularly important with those powers of attorney, because those powers of attorney, though they expire upon your death, while they're in effect, you really want someone who is your agent under your medical power of attorney to have a level of comfort with medical decision making for you. And that means you need to have a conversation with them about, okay, when I can't direct my medical care, this is what I want. And here's my advance directive. Here's my dementia plan. So we want to make sure we choose the right people, not only to care for us, but to care for, obviously, our pets. No, it is never too early to start thinking about end of life care, unfortunately. Long-term care insurance can be cost prohibitive, and I recognize that. If you're young enough to get it and you can afford it, please get it. Most people don't have it. So they are faced with either planning for a need for Medicaid or to self-pay. It's really important to consider costs of long-term care, and to also consider what kinds of steps you can take to protect certain assets from the purview of Medicaid in advance, at least 5 years in advance of applying for Medicaid. Those are tough conversations to have, because when we talk about Medicaid and we talk about removing assets from Medicaid consideration, we're taking them out of your control. And most people don't want to have their assets out of their control. But these are conversations that need to happen. Long-term care is a reality, not for everyone, but many of us will need care at the end of our lives, and we need to recognize that and at least have a degree of planning for it. So what you can do today, and this is my kind of, initial step for clients, potential clients, is to do a cursory inventory of not just what you own in terms of finances, but find out who exactly owns it, who's on the account, who's the beneficiary of the account. Is your checking account a pay on death or a transfer on death? And go through the whole list. And then look at your real estate. Who's on title? Should there be, or is there an option of doing some kind of deeding strategy to keep that home or property out of probate? So the inventory is really important. There's also the inventory of personal items to really consider who you want certain things to go to. I think it's important, again, to think about your animals. I think it's important to think about long-term care. So it's a basic inventory of what's in place and how you would like it to go. That's what you can do today. So as we've discussed, I do comprehensive estate planning. A lot of people think I just want a will. Well, I don't just do wills. Wills that I do generally have 2 trusts built into them, but that is just the start. One of those trusts is for a beneficiary who's disabled at any age, and one is for somebody you can choose the age, but it's usually 21 or under, a trust for them, because we don't obviously write checks to 16-year-olds. The next documents are the financial power of attorney, medical power of attorney. A financial power of attorney, the way that I do mine, and it can be changed, is they're not based on incapacity. A financial power of attorney, an agent is appointed, and it's what's called a standing power, meaning as soon as they're appointed, they can have access to your bank accounts. This is because people need help with their finances long before they become incapacitated. It's very, very important. This role must be someone you absolutely trust to help you in case you need assistance with your finances. A medical power of attorney is like a financial power of attorney, a springing power. As long as you can make your medical decisions, you get to make them. An agent under a medical power of attorney only makes decisions for you when you can't. Then there's the living will. We've touched on the advance directive. It covers terminal illness. It covers a persistent vegetative state. And my living will also covers COVID-19 and its variants. The reason I added COVID-19 is because with a terminal condition, we're choosing to have, say, for instance, a respirator. With COVID, we can live with a respirator for a long time. So we separate out COVID as a separate situation. We don't want just 3 days on a respirator with COVID. I had a 92-year-old neighbor who lived for 21 days on a respirator with COVID and lived to do yard work and have a good rest of his life. We want to be very careful with advance directives and how they make those decisions in those certain situations. Again, I also do a form called Planning for Dementia that contends with mild, moderate, and severe dementia. I do a HIPAA release. It's kind of doing double duty with the medical power of attorney, but we always want to have clear instructions. The very onerous privacy law can be overcome by your agent under your medical power of attorney, and possibly your agent under your financial power of attorney as well, which I recommend because if your agent under your financial power of attorney is paying your medical bills, we want agent to have access to your medical records to make sure those bills are accurate. We have a last wishes declaration. That, of course, concerns whether or not you want to be buried, cremated, or entombed. If you want a green burial, those are very popular now. What kind of memorial or funeral service? That's where my hat as chaplain comes in so strong, is because I think it's important to leave directions about your memorial service. People need to know. I have seen fist fights over what was mom's favorite song. I really encourage you to avoid such scenarios and write down your favorite songs and readings and plan your memorial. I also do a document that nominates a guardian and conservator should one ever become necessary. Your wishes regarding that guardian and conservator are very important, and a court will give great deference to your choices of those roles. We provide a service to our clients called DocuBank, where your medical directives, HIPAA release, are all uploaded to secure cloud storage that your medical care providers can access. This is to prevent the need for you to carry around your medical power of attorney with you wherever you go or keep it in your glove box. This is to ensure that it's always accessible in case of need. And then finally, I have a trusts and then a question mark, because depending on your asset picture, depending on what your goals are, will give you peace of mind. We always have the options, and this ties in also with some Medicaid planning if that ever should become necessary. The idea of self-standing trusts apart from that will with its two trusts. They can be very useful, and they can also be huge pains in the neck to administer, and I don't use them lightly. I don't think everyone needs one. Sometimes people do, but it is not just a perfect solution to all kinds of things. And one of the things that gets bandied around a lot is avoid probate at all costs. Well, I practiced in New York, and in New York, you do want to avoid probate at all costs. But in Colorado, we have a very efficient probate system. And even though if you put everything, including your stocks, in a trust, you may avoid probate, the administration of that trust can be more headache than it's worth. And so I always try to advise clients that I don't do work that isn't necessary, but I will explore all the options with you and be happy to do so. So those are the documents that I generally do. Sometimes we should have probably listed deeds, but we can, when we meet, talk about what kind of real property or real estate that you own and whom you want it to go to. And if doing a beneficiary deed or transfer on death deed it's the best option for you. I want to do a plan for my clients that really is tailored to what reflects their values and what gives them peace of mind.